All right, all right, all right. Before we actually get into what Mark Milley actually did and stuff, for those that don't already know, or for those that you just want to hear what Doc has to say about it, we're going to go over what treason actually is according to the actual Constitution. So when I make my determination, all of you Milley haters that want to put him up against the wall and get shot for treason, why I don't think he is guilty for treason, but why that's not me saying that he shouldn't be arrested, court-martialed, and prosecuted to the highest extent of the law. But let's get into this and just get into it because government documents are long and
That's how winning is done.
uh, so Article 3, Section 3, Clause 1. Treason against the United States. So this is from the Clause in Doctrine and Practice, right? So treason against the United States shall consist only in levying war against them or in adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless or testimony to two witnesses to same overt act or a confession in open court. I don't think we have the last two things. And I mean, and the reason why it is so specific like this is because it's to prevent the government from just being, you treasonous scum. It's to protect our uh, uh, it's to protect our freedom. And I'm looking up at to stick fast to something, stay attached, to remain devoted to and support of a something, or what to care, plan, scheme, operation, deviation. And I mean, there might be an argument to had that he was adhering to the enemies, but since we're not in open war with China, there's like sedition might be the highest we can go. And if we over ask for this, he's gonna get off because that's how a system works. Levying war. Early judicial interpretation of the meaning of treason in terms of levying war was conditioned by the partisan struggles of the early 19th century, which involved the treason trials of Aaron Burr and his associates and ex-parte Lei-Meng, which involved two of Burr's Confederate Chief Justice Marshall speaking for himself and three other justices, confined the meaning of levying war to the actual waging of war. However, fictitious may be the crime of conspiring to subvert by the force of the government of our country. Such conspiracy is not treason. And this is what I was going with. This is my whole thing. Why we're gonna get into it. Why he didn't um commit treason, because we're not actually at war with China. To conspire to levy war and to actually levy war are distinct offenses. The first must be brought into open action by the assemblage of men for the purpose of treasonable in itself, or the fact of levying war cannot have been committed. So far has the principle been carried that it has been determined that the actual enlistment of men to serve against the government does not amount to levying war. Otherwise, we wouldn't be able to have militias for that intent, as the Second Amendment implies. Chief Justice Marshall was careful, however, to state that the court did not mean that no person could be guilty of this crime who had not adhered in arms against the country. On the contrary, if war be actually levied, that is, if a body of men be actually assembled for the purpose of effecting by force in treasonable purposes, all those whom perform any part, however minute or however remote from the scene of action, who are actually leagued in the general conspiracy, are to be considered as traitors. But there must be an actual assembling of men for the treasonable purpose to constitute a levying of war.
That's how winning is done.
Merely didn't bring against we're not at war with China. Like it doesn't fit the definition. On the basis of these considerations, and because no part of the crime charge has been committed, in the District of Columbia, the court held that Bolliman and Swartwort could not be tried in the district and ordered their discharge. Marshall continued by saying that the crime of treason should not be extended by construction to doubtful cases, and concluded that no conspiracy for overturning the government and no enlisting of men to effect it would be an actual levying of war.
That's how winning is done.
Not long after the Chief Justice went to Richmond to preside over a trial of Aaron Burr, his ruling denying a motion to introduce certain collateral evidence bearing on Burr's activities and significant both for rendering the latter's acquittal inevitable for the qualifications and excerptations made by the Bolliman decision. In brief, this ruling held by Burr, who had not been present at the assemblage on Blennerhassett's Island, could be convicted of advising or procuring a levying of war upon the testimony of two witnesses to who has procured the assemblage, the operation having been convert. Such testimony was naturally unobtainable. The net effect of Marshall's pronouncement was to make it extremely difficult to convict one of levying war against the United States, short of the conduct or personal participation in actual hostilities. And it's like that we do this for a reason, because the government could just be like treason, 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 if it wasn't so ridiculously hard to do to protect our freedom.
That's how winning is done.
I mean, freedom is a double-edged sword sometimes. Sometimes the right free thing isn't the best thing for you
That's how winning is done.
in your particular case. It is what it is. Aid and comfort to the enemy, the Crane case. Since Bolam, the few treason cases that have reached the Supreme Court were outgrowths of World War II and have charged adherents to enemies of the United States in the giving of aid and comfort. And the first of these, Crane versus United States, the issues whether the overt act had to be openly manifest treason, or if it was enough if, when supported by the proper evidence, it showed the required treasonable intention. The court, in a 5-4 opinion by Justice Jackson, effect took the former view, holding that the two witness principle interdicted imputation of incriminating acts to the accused by circumstantially, as I told you, the fucking law is ridiculous evidence, or by the testimony of a single witness, even though the single witness in question was the accused himself. Every act, movement, deed, or word of the defendant charged to to constitute treason must be supported by the testimony of two witnesses. Justin Jackson asserted Justice Douglas, in a dissent in which Chief Justice Stone and Justice Black and Reed concurred, contended that Cram's treasonable intention was sufficiently shown by overt acts as attested to by two witnesses, each plus statements made by Craner of the witness to stand. We're not going to go over the other cases in this. You can read up more about this yourself. But we do not have two witnesses to Millie's actual like phone calls with the Chinese government. We only have one, which is himself, because he admitted to having the damn phone calls, which is stupid because we can't get him for treason, but that's definitely seditious. And he should go to court martial and stuff for that. I'm just fucking saying. Fucking saying.